Hello, everyone. My name is Ariella Wagner. I'm the founder of SunRay Construction Solutions, a national construction document service. We help thousands of general contractors, subcontractors, and suppliers secure their lien and bond claim rights. Today, we have another fabulous webinar conducted by Bryan Thomas. And today's part 2 of our 10 series is Preserving a Lien, Timing and Filing Requirements. So without further ado, I introduce the fabulous Bryan Thomas.
Thank you, Ariel. We are going to dive right back into where we were. A couple introductory things you'll see on this slide as far as welcome to the webinar and how to navigate around if you're new. We hope you are, and we hope you're getting something out of these webinars. As we go forward, here's the list that we've got of upcoming webinars to sort of complete our 10-part, or actually 11-part here, Tennessee lien law summary, and gets into some of our prompt payment acts. So be on the lookout for these dates, and we'll see you on those dates. As we get started today, I kind of wanted to take a minute for anybody that missed the first part and just do a quick recap of what we hit last week, which was some of the basics. It's who has lien rights in Tennessee. It's prime contractors and remote contractors. And I'm going to get back to that in one more slide, but that's a very broad net under the Tennessee lien laws. And it doesn't limit things like suppliers of suppliers or second tier subcontractors like you may see in certain other states or under the Miller Act. What work? Well, we went over it last time, and it's going to be an improvement, and an improvement is defined under Tennessee lien law, again, pretty broadly, and it's going to include furnishing. So just be aware, we've got a pretty broad net of what work can constitute or support a lien claim in Tennessee. On what property? Again, pretty broad in Tennessee. It's real property or an interest in real property, excluding things owned by the government or public projects. Now, it's also excluding projects where a payment bond has been recorded. Now, we also discussed for how much, and we talked about the limit of a contract price. I threw that back on the screen because it's a pretty broad definition for you. Take another look at that. Know that lien does have to be backed in a contract in Tennessee, but that contract can be oral. And absent an express agreement on price, you're going to get the reasonable value of the items in the definition here. Again, no interest, no attorney's fees. Okay, so that brings us to where we are today. And where we've got to start today is separating, as our lien law does, between prime contractors and remote contractors. Those two terms are a little funny, but that's what's used in the Tennessee lien law. And we've got a graphic on the screen to give you a pretty good overview. Essentially, a prime contractor is going to be anyone that has a contract with the owner. What you'll see on the screen here is what I would call a pretty typical setup, where an owner has hired a general contractor that is doing 99% of the work, but has hired a landscaper to come in and do all the landscaping in the end directly. Under that scenario, the landscaper is going to be a prime contractor just like the general contractor. Anyone contracting with the general contractor or the landscaper are all going to be remote contractors. And anyone contracting with a remote contractor is going to be a remote contractor. So again, under Tennessee, we've got two primes, remotes. One of those two buckets. Today, we're going to focus just on that prime contractor bucket. In a couple weeks, we're going to focus just on the remote contractor bucket. You got to use those earmuffs a little bit if you're a remote listening to the prime, or vice versa, a prime listening to the remote in 2 weeks. But for today's purposes, let's all focus on prime contractors. What do prime contractors have to do in Tennessee to preserve their lien rights? So we start with, are there any pre-work notice requirements? A lot of states require notice to go out to preserve lien rights in various different forms. Tennessee is not exactly there. In fact, our lien law doesn't require anything at all. We've got a separate section of the code, Truth in Construction Act, which is a sister to our Prompt Payment Act. And it used to require pre-work notice for any non-residential project. That changed as of a couple months ago. And now it's the exact opposite. With our 2020 amendments to the Tennessee lien laws, really all the construction statutes, the pre-work notice is now required for residential projects. And I got a question after our last webinar, what is a residential project in Tennessee? And I threw up on the screen the definition that we have in our statutes. And it's really based on how many units are there? It's going to have to be less than 4 to qualify. And do we have an owner that's going to reside in one or more of them? If you don't have both of those aspects, you don't have a residential project, and we're going to fall under the rest of the requirements. So a lot of the investment type projects, townhouse type projects, aren't going to be considered a residential project for the purposes of Tennessee lien law. Now, I will tell you that the notice that is required, again, after the 2020 amendments, the notice is only required for residential projects. The notice, there's a statutory approved form. I believe SunRay's got some that can help you as well to get the notice out. What I will tell you is I get a call a lot of times of, you know, under the old statute, Brian, we've got a project, we didn't send any pre-work notice, you know, so we don't think we have lien rights. One thing you've got to remember under Tennessee law, the notice requirement, again, is not in the lien section. It's under the truth in construction. So not providing the pre-work notice is technically a criminal offense in Tennessee. It does not affect your lien rights, or should not, is probably the better way to say that. So even if you don't remember and are working on a residential project to send this pre-work notice, don't fret. Good practice is to do it, but even if you have it, all is not lost. So that's residential projects. What about the other projects? In Tennessee, there is no notice requirements at all pre-work to preserve lien rights. So that's nice. It helps. Actually, pre-work notice was discussed during the 2020 amendments, and we ended up leaving it where it was, other than revising the section that I mentioned in the Truth in Construction Act. Now, the other thing when we're talking about pre-work, what can you do? Tennessee lien statutes do allow you to record the contract. What do I mean by that? I mean that a prime contract or any contract with the owner can be recorded in the chain of title. It is very rarely done. I would tell you that from a protection standpoint, it can simplify things in the sense of you don't have some other notice requirements down the road. Practically, it's pretty infeasible for anybody doing any sort of volume of work to record their prime contracts to take advantage of this section of the lien statute. So I tell you, it's there. It's an option for you. It provides some protection, particularly on the priority side, if you don't end up recording a notice of lien on time. But it's not something that's required. It's simply optional. So with that said, when do we have to do things under Tennessee law? Well, there's a two-part really process for prime contractors. One is recording a notice of lien. The other is filing a lawsuit, and there's a number of things associated with that to perfect the lien. Now, that may be a bit confusing as I go through here, so hang with me. We're going to first talk about the recording of a notice of lien. And this is where you go record in the chain of title a document of what most people would consider the lien. This is what people will see if they do title searches on the property and such. Now, my first line here, irrelevant if prime contractor recorded the contract. And that's what I was talking about pre-work, if a prime contractor takes the prime contract and records it in the chain of title. That's to put everyone on notice. So there is no need to actually record a notice of lien. Now, Here's where things get a little bit tricky. The 90-day requirement is a requirement to preserve priority via a good faith purchaser. If you don't do it as a prime contractor, it doesn't mean that you've lost all your lien rights. It means that you've lost potentially priority against somebody who purchases the property. And that gets to our second step on the 1 year. But let's stay first on the notice to record the lien. And this is the 90-day requirement. What I will tell you is a lot of people, a lot of prime contractors don't follow this 90-day requirement. Instead, they sort of leave it up in the air. And the reason they do that is because there is also a requirement under the Tennessee lien law that an owner give a prime contractor and any certain certain remote contractors notice if the owner is going to sell the property. Now, in theory, it works great. Prime contractor can sit back, wait for an owner to send them a notice, then they can go record their lien and move forward. What I would tell you is life is not always that simple when you get into it. Best practices is still to go ahead and record a notice of lien within 90 days, and we're going to get 90 days of completion or abandonment. We'll talk about that in a couple minutes. Rather than wait on the 1 year deadline. And the biggest reason for that is really a priority issue. And for a prime contractor, if you record in those first 90 days, you're going to get to go all the way back to what's called visible commencement, which we'll get to in a couple months. If you record outside that 90 days, you're only going to get priority as of the date you file that lien. So keep that in mind when we're talking about the 90 days. And again, I tell people, you need to do it. But if I get the phone call, Brian, we're 120 days and we haven't done anything out there and the owner's not paid us, what do we do? My answer is going to be, go ahead and record a lien. There's no reason not to go ahead and do it outside the 90-day period. So one other question I get a lot of times when we're talking about the recording of the notice of lien is, do I have to notify the owner or the lenders? Now, this is a bit of a tricky and hairy issue. And I tell you, my read of the Tennessee lien law is the answer is no. At the time you record a notice of lien, this is in the 90-day notice, you do not have to notify the lenders or the owners. That said, good practice is to do so. I almost always do so. And I will tell you, you're going to have to do so when we get to the perfection stage, because the definition of owner is written so broadly in Tennessee that it's going to include lenders. My practice, and what I would suggest for most of you as you're considering this, is if you're to the point of filing a notice of lien, communication and notice to those involved, particularly with our Prompt Payment Act, which is a little separate from the lien, is you go ahead and provide the notice to any owner, which is going to include any lender as they have an interest in the property. So that gets us through the 90-day. The question is, what do you file? Well, what you file is, and again, Ariel and her team can help with some of these forms. There's a statutory based form that helps. I believe Ariel and her team has some as well. You're going to have to file a sworn statement. So number one, whatever you file is going to have to be put under oath with a verification page by somebody who has knowledge. And it's going to have to be the amount of the work and a reasonable description of the real property. Now, those two elements being the amount of and a reasonably certain description of the real property, that's what's required in the statute. The statute form also goes on to require you to put a little bit of description of what work was there and when the date of last work is. There's a little bit of a gray area in question between the Tennessee bar or construction bar as to whether you have to include the description of the work, the last date. Again, I think good practice is to go ahead and do so you don't have to have that discussion or debate. And if you're using Ariel's forms, if you're using the statutory forms, you're going to be okay there. The reason you've got to watch all those, particularly the date of last work, and again, I'm talking about prime contractors today, is the 90-day requirement and the 1-year requirement, because those typically are going to be what trigger those two requirements. Now, one thing that is nice in the Tennessee lien law is that there is a presumption that whatever is in the building permit is accurate. And that's practically really, really helpful as you're doing this. Because if you can get a copy of the building permit, you know that you're going to have a good enough description of the property, which a judge is likely going to hold up, as well as the name of the respective parties. So if you can get your hands on a building permit, the way our lien laws are written, grab it and make sure your lien matches. Now, street address. Certain states go different ways on this. Certain states require a legal description, certain states don't. We've got some case law that actually say that a street address is enough, and that's pretty consistent with what you're going to see on the building permits, because they're almost always going to have a street address rather than a legal. That said, there's also a requirement, and we'll get into this in some future webinars, as to liening the correct property. And the case law, the judges that have looked at this have required it to go down to the smallest level of real property. And as you're getting into multifamily developments or condo units, for instance, there's some case law that says, look, you can't lien the entire project. You can't even lien an entire building. You need to put your lien with respect to the individual condo within that building in which you did the work. And there's a lot of specific allocation requirements in our lien law. And again, we'll discuss those later, but there's some exceptions that allow you to lien a bigger parcel like the project, or to lien a building, or how you go about allocating. And again, we'll get to those later, but as you're in the notice of lien form, just be aware you've got to know what property you're liening, and be aware that if you can get that building permit, you can feel pretty comfortable that the information you have is correct and really only have to worry about the allocation piece. Okay, that's our 90-day notice of lien filed in the chain of title. Again, not required for a prime contractor to preserve their lien against the owner, but it is required for saving priority against other parties. So that gets us to the 1-year requirement. The 1-year requirement in Tennessee is to perfect the lien. And we're going to talk about this in, I believe, a month and a half or so. And this is going to include writs of attachments, bonds, etc. But this is the real requirement for a prime contractor. Again, the 90-day is sort of optional, with the exception of bona fide third parties purchasing the property. So the 1 year is what you've got to make sure that you comply with as a prime contractor. And again, the 1 year, you don't ever actually have to record anything in the chain of title if we're talking about your rights vis-a-vis the owner. So with that, the question always comes, okay, I hear 90 days, I hear 1 year. Give me a little bit more about what that means. Well, our lien law is somewhat clear and somewhat vague on that. And the answer is it's 90 days or 1 year from completion or abandonment. There is, with respect to prime contractors, it's a whole lot easier to interpret than it is, as we'll get into next month, with remote contractors. The abandonment is, has the project been abandoned? The completion is, has it been completed? Now, on the completion side, there's a number of cases out there that say, if you're doing punch list work, if you're doing warranty work, you've already completed. And the way the case law turns is it looks more at what would typically be viewed as substantial completion, or can it be used, can the property be used or the improvement be used for its intended use. So that's kind of the line of demarcation. I generally advise clients, if you're thinking substantial completion, instead of the word completion, you're probably thinking correctly. So think in terms of your deadlines from substantial completion. The other thing I tell you is abandonment. I mean, if there's 10 letters saying I'm the prime contractor, I haven't been paid, and I'm abandoning the property as of today, well, we know what that date of abandonment is. It gets kind of tricky when you've got an owner abandoning. But what I'll tell you is Tennessee lien law does have sort of what I'll call a cleanup requirement here, and what they do as a deemed abandonment, a situation or set of facts which will be deemed abandoned for the purposes of the 90 days and the 1 year. And that's what you're seeing on the screen in black. And really this turns on, is there an intent, is there expressed intent of an abandonment for, or a delay for at least a certain period of time. So just a typical, hey, we're going to go, but we're going to go in 30 days, or even we're going to go in 100 days probably doesn't get you there. Hey, we may or hope to go in 100 days, but right now don't really have a plan, doesn't. And by that, I mean, you're probably going to be back to the deemed abandoned section of the statute. And I will tell you, the deemed abandoned, you'll see the 90-day period here. It's not deemed abandoned as of the 90th day. It's deemed abandoned as of day 1. So if you're running into a situation where you're close to a deemed abandonment, then you need to be thinking about your lien rights in terms of day 1 when that deemed abandonment would have started, not the 91st day. So I will leave you there on the deemed abandonment. One thing that we've got to hit while we're talking deadlines and timing for prime contractors is, I just told you all about 90 days and 1 year. Sounds great, sounds easy. Well, we got to make everything a little bit more complex. And we've got 2 things that really do that under the Tennessee lien law. One is a notice of completion. And this is what the owner can file at the end of the project to shorten the time in which you have your lien rights, or your lien rights will be extinguished. Again, it turns on whether it's a residential project or a commercial or other project. And what happens is a notice of completion is filed on a residential project. You've got 10 days to record your notice of lien or perfect your notice of lien, otherwise it's gone. On any other project, it's going to be 30 days after a notice of completion. Now, it's a statutory form again that a lot of lenders want to see filed and that they are going to rely on. And I think that is sort of the industry standard. I think courts have been pretty receptive to that concept. That said, there's been some case law that's really driven, I think, by probably the facts of the cases, where people were filing notices of abandonment before the projects were actually completed. And in most of those situations, it wasn't really a lending or funding based issue. And the courts have actually thrown those notice of completions out when the project was not 100% complete, and allowed lienors to have their typical standard periods rather than the shortened periods. So I tell you all of that to know, if you see a notice of completion, and again, these should be served by the owner on any prime contractor, you've got to react. Don't sit on your hands. There are some arguments that can be made later, but generally you need to react. The other thing I will tell you is there's also a lien enforcement demand, and these are with respect to liens that are recorded in the chain of title. Again, our 90-day requirement. So what an owner, or even if we're looking downstream, prime can do is force anyone who has recorded a notice of lien to file suit to perfect that lien within a 60-day period. So for instance, a prime that records a lien within its 90 days, if an owner comes back immediately with a lien enforcement demand, the prime contractor, rather than having 1 year to file suit, to perfect their lien is now down to 60 days from the receipt of the lien enforcement demand, or 150 days at that point from abandonment or completion. Now, that said, I don't think I've had any questions. If I have, it'll give.
So far, you've done such a great job that you don't have any questions.
Well, I
But maybe...
hope the audience actually agrees. I'll give it just a second more to see if we have any. All right, seeing none, we will let you go and let you know that we will be back again in about a month, and we'll be talking about remote contractors and what they have to do to preserve their lien rights in Tennessee. Again, a lot trickier than primes. Primes, again, we've got our 90 days to record our notice of lien and 1 year to file suit to perfect those liens. Any questions, we're happy to take them. Otherwise, have a great day.
You know what, Bryan, what we'll do really quickly is let's go back to the other screen, because if someone does have a question, we'll put your contact information and my contact information. So sometimes after the presentation, people will make some notes and they'll go, oh, you know what? I have this question. I should have asked it. So hold that up there. There's Bryan's contact details and my contact details. If anyone needs anything, feel free to give us a call or email at any time. And as always, Bryan, you did such an incredible job. No one has any questions. They're becoming lien gurus of Tennessee.
I hope so.
Well, thank you again, and I wish everyone a sunny and fabulous day.
Thank you.